What is a hardship withdrawal from a 401k or 403b plan? Under the Employee Retirement Income and Security Act, ERISA, a 401k or 403b plan may only permit participants to withdraw funds from the plan under specific rules. For current employee participants, the distribution rules generally severely limit withdrawals. One common form of withdrawal for employees is a hardship distribution. A hardship distribution is what it sounds like. It is a distribution permitted to help the employee cover a financial hardship with retirement funds. There are generally two types of hardship distributions. 1. Facts and circumstances hardship withdrawals, and 2. Safe harbor hardship withdrawals. An employer can choose what, if any, hardship withdrawals to permit. Safe harbor hardship withdrawal rules. Most plans allow hardship withdrawals under the safe harbor rules, which currently allow hardship withdrawals for 6 reasons. The purchase of the employee's primary residence. Medical expenses of the employee's spouse or other dependent. Tuition and other educational expenses for the next 12 months of post-secondary education for the employee's spouse or other dependent. Payments necessary to prevent the eviction of the employee or to prevent the foreclosure of the employee's primary residence. Funeral expenses for the employee's spouse or other dependent. Certain expenses to repair damage to the employee's principal residence caused by catastrophic damage. Under the safe harbor rules, the employee may receive a hardship distribution under one or more rules of the employee's deferrals. The employee may not receive earnings or employer contributions, except certain employer contributions prior to 1988. The employee may only receive as much as the employee can document is necessary for one or more of these reasons. The employee must allege to the employer that he or she is unable to satisfy these expenses from another source, such as insurance payments. Current IRS regulations require employees to exhaust all other loan and withdrawals from the plan before a hardship withdrawal, and the employee cannot make future deferrals to the plan for the following 6 months. Facts and circumstances hardship withdrawal rules. A 401k or 403b plan sponsor may allow additional or alternative hardship withdrawals based upon circumstances beyond the safe harbor rules. These are often referred to as facts and circumstances hardship withdrawals or unforeseeable emergency hardship withdrawals. The rules for these distributions are similar. However, the plan sponsor determines its own reasons why it will approve a hardship withdrawal. The 401k or 403b plan must provide clear explanation under the plan rules what constitutes these facts and circumstances that permit a hardship withdrawal. The employee's ability to request a hardship withdrawal is still limited to the employee's need, and the employee must exhaust other financial options before turning to the hardship withdrawal. The facts and circumstances hardship withdrawal differs in not requiring a 6-month suspension of deferrals. The employee can receive employer matching contributions and non-elective contributions. Why ERISA and IRS regulations limit hardship withdrawals at all? As an employment lawyer who deals with ERISA retirement plan issues, I have long heard questions around why ERISA regulates hardship withdrawals at all. These are understandable questions for several reasons. After all, the funds in your 401k or 403b plan are your deferred compensation and funds from your employer earned as part of your overall compensation. Expecting the same from your employer-sponsored retirement plan is not an unusual expectation. However, there are several reasons why federal employment law and your employer's plan rules limit hardship withdrawals and other distributions. The primary reason why ERISA and its accompanying regulations limit pre-retirement distributions is to encourage retirement savings. Taking your funds out prior to retirement directly opposes that goal. Permitting a limited range of pre-retirement distributions strikes a balance between helping employees save for retirement and discouraging savings because employees may need access to the funds in the event of a financial emergency. Can an employment lawyer help me get a hardship withdrawal if the plan administrator says no? Another common question directed to employee rights lawyers is what can be done when a plan administrator denies a hardship withdrawal request. Do you qualify under the plan's hardship withdrawal rules? The first issue is whether you qualify for a hardship withdrawal under the plan's rules. ERISA statutory and regulatory rules require plan administrators to administer the plan within plan rules uniformly and consistently. The plan administrator cannot create new hardship withdrawal reasons even if your situation would qualify as an unforeseeable emergency under ERISA. The plan administrator also cannot create different qualification rules for your withdrawal request. Instead, your hardship withdrawal request must fall within one of the reasons specifically described by plan rules, and you must provide the documentation of the hardship within the plan's normal approval procedures. To determine whether you comply with the plan's rules and procedures, an employment lawyer will often need to review the plan documentation against your request documentation. Did my hardship withdrawal request comply with plan rules? Sometimes plan administrators and their agents fail to process an appropriate request for a hardship withdrawal, but often people fail to submit proper requests. Determining what will cure a failed application for hardship withdrawal application is usually not a difficult process if you understand how retirement plans process these requests. In some cases, problems arise although the plan received a complete and compliant request. These may come from technical problems processing the application or a manual error by somebody in the midst of processing your request. Sometimes people involved in your employer's retirement plan do not fully understand hardship withdrawal rules, which can cause unnecessary delay. These are situations where an experienced employment lawyer can help you navigate the process by working with your plan administrator to resolve errors in the process. On the other hand, your request may be deficient because an application was incomplete or the supporting documentation does not adequately support the request. Plan administrators often require specific documents to approve a hardship request, and you may not have access to the specific document at this time. An employment lawyer can review your plan rules and work with the necessary parties to cure your application and get the hardship withdrawal approved as quick as possible.